Okay, the person that's on Zoom, would you please state your full name?
Maisha Mercadale.
Um, okay, Maisha. Okay. Now, Miss Mercadale, today is a arraignment. You're supposed to be here in person.
Yeah, I know I couldn't. My bride stopped answering the phone last minute last night, so I couldn't make it in Houston. I mean, in Beaumont from Houston.
Okay, now we're going to be doing this here arraignment. Um, I mean, you're on Zoom. You're in court. You're either gonna have to take that whatever you have on your head off, or
Oh,
you
I'm
have to
sorry.
put your mic on, take your video off.
Okay, I'm gonna turn it off.
Okay, put your mic on mute.
Okay.
All right, thank you. We'll be getting started in a few minutes. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are your more serious type offenses, whereas your misdemeanors are considered petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, felonies are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, the first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years in the state penitentiary to a maximum of 10 years, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is a minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. The person is convicted of a first-degree felony. The range of punishment is a minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishment. Now, the punishment that you have for a misdemeanor case, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanors are cases that are normally handled, or well, they start or originate in the city court, which is the municipal court, or the JP court, which is the justice court. For example, a case for not having your seatbelt on is a Class C misdemeanor, or speeding is a Class C misdemeanor. And so when individuals are found guilty in the JP court or the city court, if they appeal their case, then the case comes to this court. Now, the range of punishment for a Class C misdemeanor is a fine only. The fine cannot exceed $500. So it's anywhere from $0 or $1 to $500. Now, if a person fails to pay the fine, or if the fine is converted to community service and the person fails to perform community service, then the court can issue a warrant for their arrest. We call that a capias pro fine, so that they can sit out the fine in jail. And every day that they sit in jail, $100 will be credited toward the fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may be eligible for one of 2 types of probation. Now, with probation, you do not actually go to jail. You serve your time in the public. So, for example, there are 2 types of probation. One type is called unadjudicated probation, and the other type of probation is called adjudicated probation. Now, unadjudicated probation, we normally refer to as deferred adjudication. With that type of probation, you do not have a conviction on your record. And if you successfully complete the probation, you will not have a conviction on your record, and you may qualify for what is called a non-disclosure. Now, non-disclosure means that we or the government cannot disclose the fact that you were on deferred adjudication to the general public. So the general public cannot have access to your criminal record because your record is sealed. Now, you notice I use the term general public. That simply means that the government can have access to it. Government or governmental agencies or departments, they can have access, and the agencies that can have access are listed in the Texas Code of Criminal Procedure. But for the most part, most of the public is the general public. So most of the public cannot have access to your criminal record. If you get a non-disclosure, your record is sealed. Now, the other type of probation is called adjudicated probation. We commonly refer to it as regular probation. With the regular probation, you do have a conviction on your record. However, if you success, there's something that is called judicial clemency. Judicial clemency means that the court can set aside your conviction. In essence, you will no longer have a conviction. And in order to qualify for judicial clemency, three things have to happen. You have to successfully complete the probation. There cannot be any more time left on the probation. And you have to be successfully discharged off of the probation. If those three things happen, the court has a discretion to set aside your conviction. And if your conviction is set aside, then you will no longer have a conviction on your record. Now, if you get another conviction later on, we call that a subsequent conviction. If you get a subsequent conviction, then what can happen is the case that you got deferred adjudication on can be brought back up. And if it's brought back up, it could be revived, resurrected, and brought back up, and it could be used against you. And if you try to get a license with Child Protective Services or CPS, they can deny giving you a license. If you have a license, they can revoke or suspend that license. Now, everyone that's here for a case, there's some clipboards that's out in the gallery. Everyone that's here for a case, make sure that you have a clipboard. Now, I'm going to go over the information on that clipboard. All right? Make sure you have a clipboard. Now, the first document on the clipboard is titled Judge's Explanation of Rights to Defendants Without an Attorney. And basically, with that document, it basically means that now, as a defendant in a criminal case, you have a right to have an attorney. This document is going to talk about the rights that you have to have an attorney in your case. Okay. And the title is Judge's Explanation of Rights to Defendants Without Attorney. Make sure that you're on that page. I'm going to go over this document with you. And it states, as a defendant in a criminal case, you have three options. Three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Those are the three options. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset, which means that you'll be given another court date to give you time to hire an attorney. Next paragraph states that if you want an attorney and you do not have enough money to hire an attorney, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, the financial questionnaire is also a document on that clipboard. It is titled, you can turn to it, it is titled Jefferson County Affidavit of Indigence. And it is 3 pages to that document. Jefferson County Affidavit of Indigence. And you're going to fill out the first page and then half of the second page. I'm gonna come back to that document and I'll explain to you, those of you who would have to fill it out. Everybody don't have to fill it out. All right. Now the next paragraph states that you may not speak to the prosecutor about your case unless you sign a written waiver of your right to representation by an attorney. What that means is for those individuals who will be waiving their right to an attorney, are giving up their right to an attorney, then you will have the right to talk to the prosecutor. The prosecutor, for those of you who are in the gallery, he's the gentleman that's sitting in the gray suit to your right. The gentleman sitting over there to your right. You'll have opportunity to talk to him because he works for the Jefferson County District Attorney's Office. And so if you want to try to work out a settlement on your case, we call that a plea bargain. You'll have an opportunity to talk to him, but you must first sign a written waiver of your right. Now, the written waiver is another document that's on that clipboard. It is titled Waiver of Counsel. It's a one-page document. It is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You can just turn to it and look at it. I'm gonna come back to it later on. All right, now let's go back to the first page. Judge's explanation of rights to defendants without an attorney. Now in that, the fourth paragraph that starts with, be aware there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, that is, waive your right to an attorney, the next paragraph says that if you choose to proceed without an attorney, you may change your mind at any time and request that an attorney be appointed to represent you, okay? So that just simply means that if you decide to represent yourself and then at some point you say, you know, I changed my mind, I want a lawyer to represent me, you can do that, okay? Now, at the bottom of that document, in bold letters or in bold print, it states defendant's choice, mark initials next to only one choice. So if you want to reset your case to hire your own attorney, so if you want to hire your own attorney, you will place your initials on the first line to the left. Okay? If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, that's the third line. If you want to apply for a court-appointed attorney, then you place your initials on the third line to the left. Now, if you have already been appointed a court-appointed attorney on this case or in these cases, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. And the last line states that if you want to represent yourself, that is, you want to give up your right to have an attorney and you want to represent yourself, then you'll place your initials on the fifth line to the left. Okay, so everybody is going to put their initials on one of those lines. Now, once you finish placing your initials on one of the lines to the left, then you will sign your name at the bottom of the document where it says defendant, and you will date it today's date on the line that is titled date, and the day's date is October 22nd of 2024. Okay? Now, everybody should have signed that document. Okay? Now, if you want to hire your own attorney, that's the only document you have to sign. Okay? So these other documents that I'm getting ready to go over, you don't have to worry about that. If you want to hire your own attorney, that's the only document that you have to initial and sign. All right. Now, for those of you who would like to have a court-appointed attorney, an attorney to represent you because you believe that you do not have enough money to hire an attorney, then you will also have to read and sign the document that is titled Jefferson County Affidavit of Indigence. Okay? And that document, turn to that document, And that document under the part that says, this portion to be completed by or with the defendant. The reason why it says either completed by you or with the defendant, with means that you have someone assisting you to fill it out. And we have our core personnel who's here, who is able to assist you if you need some assistance. But it basically says we just gonna go down. It starts first name, middle initial, last name, date of birth. Then the next line says phone number is your home, your cell, your work, or your family member. And now the third line says, I receive. If you receive Medicaid, you check the box. If not, don't check it. If you receive SSI, you check the box. If not, don't check it. If you receive SNAP, check the box. If you don't check it. If you receive TANF, check the box or don't check it. Or if you live in public housing, check that box. Or if not, you don't check it. Then it says, it goes down to the next line. It asks, are you employed? If you're employed, it asks you have a job somewhere, yes. If you don't, no. And now those of you who check yes, you have to say where you work, name the company that you work for, and what type of work that you do. The next line is going to ask the number of hours that you work. Do you work 40 hours a week, 20 hours a week, 50 hours a week, whatever? How long have you worked at that job? If you worked at that job 1 week, 1 year, a month, couple of years, you list that. Then where it says number of hours, well, it also says how long have you worked there, that's the number of years. Next line, marital status. If any one of these apply to you, if you're single, check the box. If you're married, check the box. Or if you're divorced, check the box. If you're widowed, check the box. Or if you're separated, check the box. One of those 5 should apply. And it says now, for those of you who are married, you're going to write your spouse's name, middle initial and last name. And we go down to the next line, says name of dependent. That is, name your children that are 18 years old or younger. So they got to be 18 years old on down. If they're 19 years old, you don't have to name them. 19 and up, you don't name them. It's 18 or down. And you're going to put their names and their ages. Now, where it says residence information, you're either going to say yes or no to rent, or whether you own, whether you reside with a family member, or whether you're homeless. All right? And then at the bottom of that document where it says monthly income and assets, to the left, your monthly income and assets, that's what you, now it says, the first line says, my take home pay is, we're not asking for your gross, but what you take home. Actually, once they take out taxes and everything else, what you take home. Now, if you do not have a job, or if you do not have any income, that's 0. If you have a spouse, you write their take home pay. If you don't, then that's 0. Child support received. If you receive child support, how much do you receive a month? If you don't receive child support, it's 0. SNAP, that's food stamps. How much of food stamps do you get a month? Okay, if you don't receive food stamps, that's 0. Social Security, if you receive Social Security, disability, you're gonna write how much you receive a month. If you don't receive any, that's 0. Other government check, other than Social Security or disability, if you receive a government check for something. Yes,
Is for the other government check, is that where we put VA disability?
that can go there. Or disability, it could go with just where it says Social Security / disability. Okay. Other government check, you could put, if you receive one, if you don't, it's 0. Other income, if you work another job somewhere, or you're receiving another income from another source, you're gonna put the amount there. Assets, do you own a car? Do you own a home? And you're gonna kind of estimate what it's worth. If you don't, it's 0. And then at the bottom, you're gonna just total everything in that column. Now, if we go to the right side of that bottom portion of the document, it asks you for your monthly expenses. rent, if you have to pay rent or mortgage, whatever you pay a month. If you don't pay anything, it's zero. Child expenses. Now, child expenses, that not only includes child support, but it's also how much are you paying on your children? You're buying shoes, clothes, toys, or whatever. If not, it's zero. Food expenses, that's for the household. How much money do you pay for the household for the food expenses? Transportation costs. Now, the food expenses, if you just get food stamps, I guess that amount will go there. Transportation costs, that's your gas, your oil, your gas, your car note, if you have a car note, and your car insurance, if you have car insurance. Okay, you add all of those up and put that on where it says transportation costs. Your phone, if you have a phone, cell phone or home phone, or both, add those up. Probation fees, if you're on probation, you're paying a probation fee, or if you're on parole, you're paying a parole fee, or if you're paying a bondsman, you put that where it says probation fees. If it's a bondsman, you put /bondsman. Now, if you have to pay any medical expenses, your medical bills or medical insurance, you're gonna place what you're paying a month on that. If you have a credit card, you're gonna have to put what your minimum amount is, and then you're gonna total everything in the column. Now, on the next page, turn to the next page. The next page, at the top, you're gonna fill out that where it says defendant oath. You're gonna fill out today's date, put October 22nd of 2024, and you're gonna read that in your sign where it says defendant signature and date. And then unsworn declaration by defendant, you're gonna write your name, your first, middle, and last, and your date of birth. Next line, your address. That's your city, street, and name, the city, the state, the zip code, and the country, the USA. And it says, when it says the last part, I declare under penalty of perjury that the foregoing is true and correct, executed in Jefferson County on the 22nd day of October of 2024. And then you stop. Now, again, that's only for individual. You only fill out this document if you're requesting a court-appointed attorney. So for those who are requesting a court-appointed attorney, you've already filled out the first document, judge explanation, and this document, you stop. You don't have to do anything else. Now, for those individuals who will be requesting to represent themselves, you didn't have to fill out the affidavit, but you will be required to fill out the waiver. The document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. That's only for people who would be representing themselves. If you're not representing yourself, you don't have to worry about that. You can just stop and just listen. Or if you hire your own attorney, you can stop. You stopped a long time ago, and you can just continue to listen. All right? And so it says waiver of counsel for purposes of entering a guilty plea or proceeding to trial. That's only for people who's waiving their right to an attorney and representing themselves. And if this document states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 22nd day of October of 2024 by the County Court at Law number 2 of my right to representation by counsel if I'm unable to afford counsel. One will be appointed for me free of charge, understanding my right to have counsel appointed to me free of charge. If I'm not financially able to employ counsel, I wish to waive that right, which means I wish to give up that right and request the court to proceed with my case without an attorney being appointed to represent me. I hereby waive my right to counsel. If that is if that's what you want to do, then you're going to sign your name on the line that is titled defendant and your date today. And that's it for the attorney. Okay, now, as a defendant in a criminal case, you also have a right to have a trial by jury. When a gentleman is sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence. They would listen to the arguments. They would deliberate, and they will decide whether to find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. If you waive or give up your right to have a trial by jury, that simply means that you will not be having a trial by jury. Your case will come before the court or before the judge in one of three ways. One way it can come before the court is by way of a trial. Somebody might ask, well, how can it come by way of a trial if I'm waiving my right to a jury? Well, it comes by way of a bench trial. That's a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to the evidence, listen to the arguments by the attorneys, and then the judge will apply the law to the facts in this case, and then decide whether to find you not guilty or guilty. Now, the other way your case can come before the judge is by way of an agreed plea bargain agreement. Now, as I mentioned to you earlier, a plea bargain is a way that you work a settlement out with the state on your case. Now, an agreed plea bargain means that you and the state have reached an agreement to settle your case. It comes before the court or the judge. The judge can do one of two things. The judge could accept or reject the plea bargain agreement. Now, if the judge rejects your plea bargain agreement, you can take your plea back. So, for example, if you're entering a plea of guilty or no contest to your charge, and you and the state have reached an agreement for you to serve deferred probation, and the judge said, well, I'm not going to follow that agreement, then you can say, well, judge, I take my plea back. I'm not entering a plea of guilty or no contest. You have a right to do that. Now, if the judge does follow the plea bargain agreement, and if you decide that, you know what, I think I've been wrongfully convicted, or the court has committed an error by convicting me, I want to appeal my case. If you want to appeal your case, then you have to get permission from the judge or the court to appeal your case. Okay. Now, the other way that your case can come before the judge is by way of an unagreed plea bargain agreement. An unagreed plea bargain agreement just simply means that you and the state have not been able to reach an agreement on your case, and you want the judge to assess the punishment in your case. The judge can give you punishment anywhere within the punishment range. So if it's a Class B misdemeanor, the judge can assess punishment from 0 days to 180 days. The judge can give you a fine anywhere from $0 to $2,000, or the judge can give you both fine and jail time, or the judge can give you probation, either deferred probation or regular probation, anywhere within the punishment range. Okay. Now, the other right that you have as a defendant in a criminal case, you have a right to have witnesses that come to court. Witnesses, they sit in that chair where the microphone is. We call that the witness stand. Witnesses, they can testify for you or they can testify against you. If you are representing yourself, you can ask a question. If you have an attorney representing you, attorney can ask them a question. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. If you waive or give up your right to have witnesses to come to court, what that means is, it means that the state will not be calling witnesses. Well, no. It means that you will not be calling witnesses if you waive or give up your right to call witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case. Now, you also have a right, a Fifth Amendment right against self-incrimination. That means you have a right not to say anything. I know a lot of times we see a lot of law shows on television, and the police walks up to somebody in one of these on what we call a PR or a personal recognizance bond. And what that means is you did not have to pay any money to get out of jail. You was released under your own personal recognizance. Now, every day that you spent in jail, that jail time can be used as credit toward your punishment. So, for example, when I say every day that you spent in jail, I'm saying every different day. So, for example, let's say you were arrested at 11:58 p.m. last night, and you got out of jail 2 minutes later at 12:01 a.m. the next day, right? That's 2 different days. You was in jail 2 minutes, but they call that 2 days. Okay. Well, that's 12:01. No, 12:59 to 12:01. Okay, that's 2 minutes. Okay, so you was in jail 2 minutes, but that's 2 different days, so you get credit for those different days. So every day that you spent in jail can be used as credit towards your fine and court costs. So for example, let's say you were in jail 5 days and you and the district attorney have worked out agreement that you will serve 5 days in jail. That means you don't have to serve no more time in jail because you get credit for time served. You've already served the time. Now, if the state is offering 7 days in jail, you serve 5, that means you only have to serve 2 days in jail, not 7, because we're going to subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. So, for example, let's say you spent 5 days in jail, that's $500 that you have credit that will go towards your fine and court costs. So if the state is offering you fine and court costs of $500, you won't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, it will be taxed and retired. Now, if they're offering fine and court costs of $700, that means you don't have to pay $200 because why? Because we will subtract the $500 from the $700, and that leaves $200. Now, you'll be required to pay the $200 on the day that you enter your plea. However, if you cannot pay the balance of $200, for example, on the day that you enter your plea, we can put you on a payment plan where you can pay off so much every month until the balance is paid off. Now, for some individuals, they don't have income, they don't have a job, and so they will not be able to pay off the fine and court costs. So therefore, we can convert the fine and court costs to community service. You will receive $12.50 towards your fine and court costs for every 1 hour of community service that you perform in a nonprofit organization. Now, so if you owe $200, for example, if you work 8 hours one day, that's $100 that will go towards your fine and court costs. So in our scenario, if you work 2 8-hour days, that's $200 that will pay off your balance. Okay. Now, also, Jefferson County has a program for people who have not been in trouble before, for first-time offenders. The program is called pretrial diversion. And in a nutshell, what they'll do is this. They'll dismiss your case, and you can get it wiped off your record. We call it expunged. In order to qualify for the program, it has to be first time getting into trouble. And then 2, it can be an offense for unlawfully carrying a weapon or resisting arrest. And 3, you have to have an attorney who will help you to make the application and submit the application to the district attorney's office. And again, if you get into that program, case dismissed, you can get it wiped off, deleted, or erased from your criminal record like it never happened. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County, which is the district attorney's office, has a program called Veterans Court. With the Veterans Court program, you'll get into the Veterans Court program. Once you complete the program, they'll dismiss your case, and then you can get a non-disclosure, which means your record can get sealed. Okay? Now, those are the programs that the district attorney's office has. Now, this court has a program that is called the CSI program. Stands for Community Safety Initiative, CSI, Community Safety Initiative. And with that program, we have partnerships with various agencies in our community. One of the agencies that we have a partnership with is Spindletop. Spindletop Center is our local mental health agency in the Southeast Texas region. And with Spindletop have the ability where they will come into the courtroom. They usually here on Tuesdays because this is the arraignment. And what Spindletop will do, they'll be able to address any mental health needs that you have. Now, you do not have to be incompetent or insane. You could just merely suffer from anxiety or depression. And Spindletop has the expertise to address your mental health needs. You can have any other host of mental illnesses. Spindletop can address those mental health needs. Now, what they will do, they will conduct a private interview either in our jury room or either at their place, their offices, or by telephone, whichever is convenient for you. And they can do an assessment to determine what your mental health illness is. And they can refer you for either outpatient or inpatient treatment to address your mental health issues. Now, if you have issues with drugs or alcohol, Spindletop also has a program that is called ATAR. ATAR, which is an acronym that's ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do is they will conduct a screening, do an assessment, and then they will develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, then they will help you to get a job or assist you to get a job in the area that you're trained in. If you have not graduated from high school or if you do not have your GED, then they also have a GED program where you can get your graduate equivalency diploma. All of those programs that I just mentioned are free, does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes because they have too much to lose. And so the program is designed to address the issue of recidivism. So I also like to say that when you come to court at law number 2, we do not have court as usual. We have unusual court. And it doesn't mean that we're different. It just means that we are trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. We have some brochures that we can help you, we can give to you, where you can make contact with individuals who are running these programs. Now, at this time, we're going to go into recess. I mentioned to you earlier, if you need assistance with filling out the paperwork, we have our court personnel who's here who will be happy to assist you with filling out the paperwork. Now, it's going to take us a few minutes because we have to pick up the paperwork from you. Now, if you need to use the restroom, there are 2 restrooms near this courtroom, right in the hallway. The first restroom, or the women's restroom, is on the opposite side of the hall in front of the 172nd District Court. And the men's restroom is on this side of the hall in front of County Court at Law number 3. Now, Do not leave the courthouse, because if you leave the courthouse and your name is called and you're not here, a warrant can be issued for your arrest. And if a warrant is issued for your arrest, you could be arrested and placed in the Jefferson County Jail. So, for those of you who need help with filling the paperwork out, what we need you to do, I'm gonna ask you just to kind of raise your hand. We're gonna have our court personnel come in and, they'll be happy to assist you, with that paperwork. So at this time, the court will go into recess, to give us time to go over the paperwork. Okay. Comes County Court at number 2 is back in session. The court is in session in one case. Case is style of state of Texas versus Marcus Miles. Clause number 24 CCCR 1538. Mr. Miles, is that your full name? Mr. Miles, would you please raise your right hand? Mr. Miles, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Miles, you may put your hand out. How are you doing, Mr. Miles?
You going on?
That's good. Mr. Miles, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed
Yes.
attorney? And is this your signature
Yes.
on the line that's titled defendant?
Yes.
I also have a document that is titled Jefferson County Affidavit of Indigenous. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Miles, before you signed and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Miles, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. That information will be taken back with you when you go into custody. You can put him in custody and he'll give you the paperwork.
Any questions for him?
What's going on with the resistance? Resisting arrest, cause I said like a month already. So like.
I mean, you had an option, that's why we gave you the option today. This is the resisting case that you're here for. And you had the option either to hire an attorney, request a court-appointed attorney, or waive your right to attorney and represent yourself. And you chose
Oh,
to.
so I couldn't, I mean, it's cool. I didn't think it was gonna be that difficult with I know the other charge, but the resistance, I didn't think it was gonna be like, you know what I mean? Cause I ain't got too many, you know, I didn't think I was gonna need, attorney.
Well, you
It's
asked
like
for,
this
but,
one.
but you asked for an attorney. That's what this document, you're here for the resisting. And so you requested that an attorney be appointed to represent you on this resisting arrest case.
I'm talking about before I came, like when I born that, I didn't know I was gonna need me a lawyer for this case. If I would've.
Oh, so you're saying that when they let you out when you bonded out of jail,
I had to sit 30 days.
yeah, you thought that, no, the case, you have to come to court to take care of your case.
Yeah, I knew
It's
I
not
was-
taken care of in the jail, even if you could sit in jail 180 days and they let you out on bond, that doesn't mean that your case is taken care of.
I knew I was gonna have to come and, deal with you or whatever on the case due to the fact of that, but I just was like, I ain't know what was what, you know what I mean? I was just trying to get at blase, and, but it's,
So my question to you is, what do you want to do? Do you want an attorney appointed to represent you, or do you want to represent yourself?
representing.
You want to represent yourself? Okay, so he needs to change, we're gonna have to strike through there and put his initials right here. And he had a waiver here.
Better yet, don't even worry about it. Keep it like that. Keep it like that.
Okay,
I'm just, let the attorneys do it.
okay, that's fine.
All right, brother.
For being recess. Are you here? Do you have any recess on the cases? Is it ready? Williams? Nayeli Herrera? This is cause number 24CCCR 1296. Case and style of state of Texas versus Nayeli Herrera. Ms. Herrera, is that your full name? Ms. Herrera, would you please raise your right hand? Ms. Herrera, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Herrera, you may put your hand down. How are you doing, Ms. Herrera? That's good. Ms. Herrera, you represented in your case by your attorney, Attorney James Macon. Attorney Macon, how are you doing?
It's Tuesday.
Okay. And the state is represented in this case by Attorney Kyle Gasper. Attorney Gasper, how are you doing?
I'm good, Judge. Thank you for asking.
Mr. Macon, do you waive a record in Ms. Herrera's case?
Yes, Your Honor.
Ms. Herrera, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. Now, in this information, it alleges that you, Nayeli Herrera, on or about April 27 of 2024, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated. The state is abandoning the enhancement paragraph. And because the state is abandoning the enhancement paragraph, that means that you will be charged with a lower included offense, a Class B misdemeanor DWI. Do you understand what you have been charged with?
Yes, sir.
And to this charge, how do you plead guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes, sir.
Ms. Herrera, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishment, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials, or two sets of initials. One set is your attorney initials, the other set NH. Did you place your initials NH on this document?
Yes.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that is titled Trial Court Certification of the Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
Now, Ms. Herrera, before you signed and initialed these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Herrera, are you a citizen of the United States?
Yes.
State offer states one.
Any objection? No objection. State's Exhibit Number 1 will be admitted. Mr. Macon, you advising counsel, Ms. Herrera, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Herrera, your attorney, Mr. Macon, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Herrera, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state is offering 2 years of deferred probation, $500 fine, 80 hours of community service, DWI first, standard conditions of probation, plus an interlock and court cost. In addition, the state will be dismissing companion case 24 DCCR 1241.
What is the court cost?
Yes, sir.
Okay. Ms. Herrera, the state is offering that you serve 2 years deferred adjudicated probation. During the 2-year probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll also be required to pay a DWI conviction fee of $100. You'll also be required to pay a probation fee of $60 a month, a analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $118 a month. Will you be able to pay the $118 each month?
I think so.
Yes.
Okay. Now, Ms. Herrera, you'll also be required to pay Jefferson County DWI initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. You'll be required to perform 80 hours of community service, install an interlock device on any vehicle that you own or operate, have an alcohol assessment, and you will be required to adhere to the other standard terms and conditions of this probation. The state will be dismissing cause number 24 DCCR 1241. Ms. Herrera, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer? Ms. Herrera, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Herrera, if you successfully complete this probation, this case will be dismissed. It will not result in a conviction on the record, and you may be eligible for a non-disclosure. And talk to your attorney about the non-disclosure because he's quite competent in those matters. Please stand in front of the court coordinator, follow her directions, or follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day. And Mr. Macon, this is your only case?
It is, Your Honor.
Okay, you're free to go as well, you have a blessed day.
You too. Thank you.
Thank you. Oh, he was supposed to take a copy. Yeah. This is called number 24 CCCR 0290. Case is styled State of Texas versus Antonio Alfaro. Mr. Alfaro, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Second document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. Mr. Alfaro, now, initially you stated you wanted to waive your right to an attorney and you changed your mind, is that
Yes,
correct?
Your Honor.
And so I need you can get his document back to him. He can make his change. There should be a pen right there. Yes.
Just the initial on the first one?
The initial on whatever line you wanted to make your change on, and you're gonna strike through the other one that you,
Put your initial next to it, that you strike it out.
All right.
Well, that won't work. Just strike through because, yeah,
All right.
I don't know if you'll use that also.
okay. All right, you can, okay, Mr. Farrow, would you please raise your right hand? Mr. Farrow, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Farrow, you may put your hand down. Mr. Farrow, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
And are these your initials on the line that state you'd like to hire your own attorney?
Yes, Your Honor.
Now, before you sign and initial this document, did you read the document?
Yes, Your
Did you
Honor.
understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Mr. Alfaro, our court coordinator is going to reset your case. Once your case is reset, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
It's gotta be shredded. Juan Velasquez Vargas. Mr. Vargas, your full name is Juan Augustine Velasquez Vargas.
Yes, sir.
Mr. Vargas, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing?
Yeah, how you doing?
I'm doing fine. Thanks for asking, Mr. Velasquez Vargas. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled defendants?
Yes, Your Honor.
And are these your initials on the line that state you'd like to hire your own attorney?
Yes, Your Honor.
Now, Mr. Velasquez Vargas, before you sign and initial this document, did you read the document?
Yes, Your Honor.
You understand what you read? And is everything in this document true and correct
Yes, Your Honor.
to the best of your knowledge?
Yes, Your Honor.
Okay, Mr. Velasquez Vargas, please have a seat in that first chair on the wall and wait for your name to be called. Joel Michael Kibido. Mr. Kibido, your full name is Joel Michael Kibido.
Yes, Your Honor.
Mr. Kibido, would you please raise your right hand? Mr. Kibido, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Kibido, you may put your hand down. How are you doing, Mr. Kibido? I'm doing fine, thanks for asking. Mr. Kibido, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
Yes,
Are these your initials on the line that state you would like to hire your own attorney?
Yes, Your Honor.
Now, before you signed and initialed this document, did you read the document?
Yes,
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Mr. Thibodeau, your case is going to be reset to give you an opportunity to hire an attorney. Our court coordinator is going to reset your case. Once you reset your case, you'll be free to go and you have a blessed day. Please have a seat in the first chair on the wall. Albert Dwayne Gilliam. Sir, that door is locked back there. You gotta go out the other door. Now, this is cause number 24 CCCR 1638, case of style of state of Texas versus Albert Gilliam. Mr. Gilliam, is that your full name? Mr. Gilliam, would you please raise your right hand? Mr. Gilliam, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Gilliam, you may put your hand down. How are you doing, Mr. Gilliam? That's good. Mr. Gilliam, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to hire your own attorney? Okay, Mr. Gilliam, before you sign and initial this document, did you read the document? Did you understand what you read?
You did a good job explaining.
Okay. Is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Mr. Gilliam, your case is going to be reset. Give you opportunity to hire an attorney. Please have a seat in that second chair. Charles Shaw. Okay, Mr. Shaw, would you please raise your right hand? Shaw, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Shaw, you may put your hand down. How are you doing, Mr. Shaw? Okay. I'm doing fine, thanks, Now, Mr. Shaw, you have two new cases. Do you recognize this document?
Yes, I recognize the document.
Is this your signature on the line that's titled defendant?
Yes,
And are these your initials on the line that state that you have already been appointed, court-appointed attorney Tom Burbank?
yes,
Okay. Now, before you sign this document, did you read the documents?
yes,
You understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay. Okay, Mr. Shaw, your attorney Burbank, he has been appointed on your previous case, yes.
those are not new.
These are not new.
No. Those are actually prior.
Okay, let's, okay, we're gonna have her to look at the computer. Hold on a minute. Well, yeah, so what you're saying is these may have been committed before your other cases, but they didn't file these until after your other cases. Okay? So these are some additional cases that you have.
Those are two misdemeanors.
Yes. Let's see.
You remember when you assigned me to Unity back in July?
Yeah,
Those were prior to them.
yeah, they occurred prior to, but the state didn't file them until just now, until recently. They never was filed. See, what happens is, if a person commits a crime, the department, either the police department or the sheriff department, or an agency in the community or in our county, they have to work the case up, and then they submit the case to the district attorney's office. Once the case goes to the district attorney's office, the district attorney could accept or reject the case. Once they accept the case, they will file the case. So even if these claims occurred before your other cases, they had 2 years in which to file the case. So they just was filed after your other two cases was filed.
Okay.
Okay? All right, so now you're still under bond conditions that you had on the previous, hold on a minute. Let me see, pull up his bond conditions. You have his bond conditions on that?
Outpatient.
Well, yeah, all of those bond conditions, those bond conditions still applies.
I'm still working on the outpatient.
Right. Now, did you, I think you were required to go to, Spindletop, right? And then you say Spindletop referred you to Unity House?
Unity referred me to Spindletop, and it got put off.
And what happened?
It got put off due to like it was like a house visit from a family sex service thing going on, and they intertwined on the same dates
Okay,
back in September.
okay,
They intertwined on the same date. I rescheduled for the outpatient,
right.
and I just kind of dropped the ball on getting into outpatient.
So you
because
never got into the outpatient?
I never did, just because of court. Like I just.
Well, I mean, that doesn't stop you from getting an outpatient, because once a person gets in the outpatient, they'll inform us that the person is in, treatment.
I just
And
missed
so
it.
yeah, well, you need to get into into that program. You're gonna be ordered to go back to, let me see.
I've been trying to keep up with all the dates.
Well,
I just kind of missed.
well, hold on a minute. No, I'm telling you, the bond conditions from not on these cases, but on the old cases. Okay, just have a seat in that chair by the wall. They're working on it. Just have a seat right there. Yeah, any one of those chairs on the wall. Zarak Scott. You can stand right there. Mr. Scott, your full name is Zarak Scott?
It's Zarek Baron Scott.
Huh?
Zarek Baron Scott.
Zarek Baron Scott?
Yes, sir.
How are you doing, Mr. Scott?
All right, sir.
You doing all right?
Yes, sir.
That's good. Now, Mr. Scott, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And there's a set of initials on the line that state you'd like to apply for court-appointed attorney. Did you place your initials here?
Yes, sir.
And are these is this your signature on the line that is titled defendant?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
Now, Mr. Scott, before you signed and initialed all of these documents that I just showed you, did you read the document?
Yes, sir.
And did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Scott, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your cases is Attorney David Grove. Attorney Grove will be given information to contact you. And you will also be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that second chair on the wall. Yarbius Gonzalez. Mr. Gonzalez,
Sir.
is that your full name?
Sir.
Mr. Gonzalez, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Mr. Gonzalez, you may put your hand down. How are you doing, Mr. Gonzalez?
I'm doing good.
You doing good? I'm doing fine, thanks for asking. Mr. Gonzalez, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney.
Yeah,
Do you recognize this document?
yeah, I recognize.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these initials on the line that state you'd like to apply for court-appointed attorney? Also, I have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled defendant. Is this your signature?
Yeah, that's mine.
Mr. Gonzalez, before you sign and initial these documents, did you read the documents?
Yeah. I read.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Gonzalez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Benjamin Jeffries. Attorney Jeffries will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat on that chair on the wall.
All right.
Okay,
Thank you.
you're welcome. Ronald Gloston. Well, good morning, Mr. Gloston. Your full name is Ronald Gloston?
Yes, sir.
Mr. Gloston, would you please raise your right hand? Mr. Gloston, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Gloston, you may put your hand down. How are you doing, Mr. Gloston?
I'm okay.
That's good. Now, Mr. Gloston, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Gloston, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed
Yes.
attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant's signature. Is this your signature?
Yes, sir.
Mr. Gloston, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Me and my niece, she went over it with me.
Did she
and
help you?
Fully understood.
Okay. And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Gloston, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall and wait for your name to be called.
Yeah.
Jeremy Glenn McMahons. Mr. McMahons, your full name is Jeremy Glenn McMahons?
Yes, Your Honor.
Mr. McMahons, would you please raise your right hand? Mr. McMahons, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. McMahons, you may put your hand down. How are you doing, Mr. McMahons?
Pretty good, Your Honor. How about yourself?
I'm doing fine, thanks for asking. Mr. McMahons, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes, Your Honor.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, ma'am.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, Your Honor.
Mr. McMahon, before you signed and initial these documents, did you read the documents?
Yes, Your Honor.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. McMahon, I read your answers to the questions. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go, but before she gives you that information, I need to give you some bond conditions. Mr. Byron, you can hand this document to me. Mr. McManus, the document that you have before you is titled Standard Bond Conditions and County Court at Law Number 2. Do you see that title?
Yes, Your Honor.
Okay, I'm going to go over this document, which in the states as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named here are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that
Yes,
condition?
Your Honor.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the rest of the defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, Your Honor.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Sir, with that one, I picked my son up from that house. Does that mean I need to get my ex-wife to just drop him off at my house?
If you have a divorce decree or custody order, I'm sure the custody order says that a third person can pick up your child.
Okay.
Okay, so you can follow your custody order on that. Okay. Do you understand that condition?
Yes, Your Honor.
And
Also, Your Honor, on number 3.
on number what?
Number 2, I have a medical cannabis card.
Well,
PTSD, agoraphobia, and anxiety.
well, like I said, it says defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, so even if it's prescribed?
Well, this bond condition states that if you test positive for drugs or alcohol when if you submit to a test for drugs and alcohol, the test indicates the presence of drugs and alcohol in your body, your bond can be revoked. Okay?
Yes, sir, but I have a prescription order.
Okay, I'm telling you what the bond condition says. All right. Now, do you understand that condition?
Yes, Your Honor.
Okay, now, condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Does that mean I can't hunt this year?
That means you cannot possess a firearm or ammunition while you're on bond. You understand that?
Yes, Your Honor.
Okay? Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant can be issued for your arrest. You can be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, Your Honor.
Okay. So have a seat in
Your
the
Honor,
first.
if I'm gonna do the Veterans Court, do I do that through my lawyer?
I think your attorney can make an application to the district attorney's office, but you have to tell him.
Yes.
Okay. All right, just have a seat in that first chair on the wall, wait for your name to be called. You're welcome. You have a blessed day. Okay. Mr. Charles Shaw.
Oh, I put it, yeah, that's all.
Okay, let's do this here. Let me see. Hold on a minute. That's. Is it one set of bond condition? Could you, write off all his cause numbers, for the misdemeanor cases on that? Mr. Shaw, for the cases that you have, okay. You need a tissue or anything? You good? Okay. Now, Mr. Shaw, the court is gonna give you some bond conditions that's pertaining to all of the cases that you have in this court. Okay? And the bond conditions is gonna state as follows. And we're gonna give you a copy of these bond conditions. Standard bond conditions in County Court at Law number 2. Following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein, you need to make a copy. Hold on a minute. They're having Trina. After do they having to have a seat? I need to talk to him. I'm gonna need a copy of this here. Just have a seat. I need to talk to him here. Now, Mr. Shaw, we're gonna give you some bond conditions. And the bond conditions are standard bond conditions in County Court at Law number 2. And these bond conditions will apply to all your misdemeanor cases that you have pending. Or do you understand that? Okay, and it says following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state or any other state. Do you understand that condition? You can't break the law. Do you understand that? Either in Texas, any other state, or even a federal offense. You can't break the law. Do you understand that?
Yes.
Okay.
Remind me of, an offense I had October 4th.
This applies to, this is saying any commit no offense.
Yes, sir. It reminded me of an offense I had October 4th this month.
Okay,
And, I went to the county on an accusation and, I think you might have signed over some paperwork for me to get my blood drawn in the county. That's what they told me in the county.
okay.
And I was just wanting to know, like, maybe when the results may come in,
You're gonna talk to your attorney about that.
I won't get the results.
Your attorney will be able to get everything, they call that discovery. Your attorney gets the evidence, you don't get the evidence, because you are not representing yourself. And even if you were representing yourself, you would have access, but you won't have physical possession, but your attorney will get all of that.
But they arrested me for a DWI.
Okay,
But I
well,
had not been.
okay, but your attorney will get that information. You understand? All right, now, the defendant number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? All right. Now, condition number 3 doesn't apply, and condition number, condition number 3 does apply. And it says the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Now, if I'm not mistaken, you are allowed to, I think on your new cases, those cases happen at the courthouse. Is that correct?
Which no.
The ones you hear for the day. The cases that happen in May, you're here for today on, let's see.
November the 18th, we were scheduled for November.
It was, no. It says, hindering proceedings by disorderly conduct. The proceedings were court proceedings. And, resisting arrest. So you are allowed to come to your court to and from the courthouse on your days for court. Do you understand that?
No, I don't understand what you're saying.
You can come to court.
I can come to court?
Yes, that's what I'm telling you. I know the incident of disorderly conduct of an official hindering proceedings by disorderly conduct. Hold on a minute. Make sure I'm gonna have it right. I need to look at it again. Sure. So you said. Which one is that? That's 18 and 19. Okay. Yeah, this one happened at the 279th District Court, which is down the hall. But I'm saying you're allowed to come to court for your court proceedings.
Allowed to come to this court?
You got cases not just in this court, you got cases in drug court too, don't you?
Correct.
So you can go there as well.
I'm allowed to come to court?
Yeah, you're allowed to come to court. We're not gonna, these bond conditions is not gonna prevent you from coming to court.
I understand.
Oh, that's what I'm trying to get you to understand. Okay.
So we're coming on the.
Yeah, so
18th
whenever your court dates are, you're allowed to come to court.
On the 18th November.
I don't know when your next court out, we'll find out later on.
Yes,
But
sir.
my question is, no, we still dealing with your bond condition. Do you understand that? All right. Now, condition number 4 does not apply. Condition number 5 does apply, and it says you will obtain and participate in Spindletop ATAR addiction treatment program. Once you get this to him. I'm on page 2, number 5. You will obtain and participate in Spindletop, which is ATAR, ATAR stands for Addiction Treatment and Recovery Program. That's number 5. Do you understand that condition?
Yeah.
Okay, condition number 6, defendant remain drug and alcohol free. Do you understand that condition?
Yes.
Now, condition number 7, you will attend AA, NA meetings 3 times a week and provide proof to the court. And I have a form here.
See where it says.
That's number 7. I wrote that in.
AA 3 times a week.
Right, and provide proof to the court. I need to give you the paperwork.
Participate in ASAP.
Yeah, just hold on. I hadn't got there yet. Okay, this is, you hand this to him. He's handing you 2 documents. First document is a document that's what you have to bring with you when you go to AANA meetings. You have a sponsor, and the sponsor is going to sign that document every time that you go. The next document is locations in Jefferson County that you can go to. The locations is like the 3 or 4 page document. The other document is a document that you have to bring with you to AANA meetings, okay? You said that you kind of dropped the ball on getting into the Spindletop program. Meetings was conflict. Well, you won't have no conflict on these meetings because you're gonna have to go to these meetings. Most of them is in the evening. You could go to them and you're gonna participate in it, and those folks are gonna let us know how are you doing in the meeting, okay? You're gonna have a sponsor, and the sponsor is usually an individual who at one time was addicted to drugs and alcohol, and they are going to kind of mentor you to help you along the way. Do you understand that?
What day does this start today?
Oh, the conditions of bond start today. Yeah, I just signed it. But you got 3 times a week that you're gonna go, and when you come to court, you need to bring that paperwork back so that we can verify that you have been attending AANA meetings. Do you understand?
Not quite. So I'm going to outpatient or am I going to?
No, you doing both. It ain't no or, and. Okay, you stated that we put you in outpatient, you didn't go. Okay, so
I missed it.
yeah, you missed it, but you ain't gonna miss AANA meetings because you can't say they didn't reschedule it because there's about 50 of them on there. You could go to either one of them.
Well, I see 20 here.
Yeah, but you only just pick out one, the one that may be closest to your house and the one that's convenient for your time schedule.
So do I go back to Unity?
You still gonna go to Unity. Now, if you get in the Unity program, then what they're going to do, you won't have to go to A because Unity is a facility where you be in their facilities for at least 30 days.
So I'm going inpatient, not outpatient?
We don't know, depending on what Unities tell you. Unity has to make that decision.
Go to Unity.
Yeah, they're gonna tell you, okay, you could do outpatient. Or they may say, no, you need to do inpatient. I don't know what they're gonna tell you. But they're gonna do an assessment to determine what you should do, okay?
So go to Unity today.
That'll be a good idea to go today.
Go to Unity today
You're right,
and find out where I'm going
right. They'll let you know, okay?
and go to.
Well, but yeah, go to Unity. They'll tell you what you're gonna do. Now, if they put you in inpatient treatment starting today, obviously you can't go to AA because you're already in treatment. Okay, now if they don't put you in, you're gonna be going to AANA meetings 3 times a week, right? Okay. All right, now, and you're gonna, participate in the ASAP program, that's also part of the, ATAR program. Okay. So, do you understand, now, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant can be issued for your arrest. Do you understand? All right, just have a seat. His case is already reset. Oh, on the back of his bond condition? Because I have the original. You have his court date is on there? Now, his court date is gonna be the same date as felony cases, right?
No, just give me the,
This here?
the ones that they still.
Oh. Yeah, that was nice, yeah. Just have a seat in the first chair, yeah.
And if I were to apply for jobs, can I apply
Yeah, you still could apply for a job.
out of Jefferson County? Like-
That doesn't prohibit you from leaving Jefferson County.
Okay,
You have to talk to your bondsman about that.
I just want to know.
Yeah,
Okay,
all right,
all right, thank you.
all right, here you go. Oh, do we have,
For the other two.
John Chisholm? Who is John Chisholm? Okay. Okay, this is cause number 24CCCR 1806. Case is styled the state of Texas versus John Chisholm. Mr. Chisholm, is that your full name?
Yes, sir.
Mr. Chisholm, would you please raise your right hand? Mr. Chisholm, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Chisholm, you may put your hand down. How are you doing, Mr. Chisholm?
Doing good, Your Honor. How are you?
I'm doing fine, thanks for asking, Mr. Chisholm. I have, where is this, is
Right here,
this
John.
waiver? Okay, Mr. Chisholm. Now, you have, as a defendant in a criminal case, you have a right to have a record. What that means, it means you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up the right to have a record in this case. Do you waive or give up the right to have a record?
Yes, sir.
You do not? Okay, just have a seat. We'll let's get a court reporter. Okay, just have a seat. Next case is who's next?
Mr. Williams or Ms. Jover?
Ms. Joubert or Joubert? Case is 09.
PS3.
10.
That door's locked.
Maybe it's over there. Okay, let me do this to Ms. Joubert. We're gonna get Mr. Chisholm back up. Just have a seat. Thank you. How you doing, Mr. Abe? This is cause number 24CCCR 1806. Case is style of state of Texas versus John Chisholm. Mr. Chisholm, would you please raise your right hand? Mr. Chisholm, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Chisholm, you may put your hand down. How are you doing, Mr. Chisholm?
Doing good, Your Honor.
That's good. Now, Mr. Chisholm, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to waive your right to attorney and represent yourself? I also have another document that's titled Waiver of Counsel for Purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes, sir.
Defendant? Mr. Chisholm, before you signed and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Chisholm, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Chisholm, it alleges that you, John Chisholm, on or about August the 7th of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place in Jefferson County, Texas. Mr. Chisholm, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Chisholm, how do you plead? Guilty, not guilty, and no contest?
No contest, Your Honor.
Now, you're pleading no contest. I think the paperwork says guilty. Yeah. The paperwork says guilty.
I think we said earlier, but I'm not opposed to a plea either, so if we need to change that, we can.
I said no contest. That's what I'd like to plead.
Okay.
Okay, so you're gonna, okay. Now, here you go. You get to
Oh,
finish
I
that.
may, actually, I think I may have been my error. So we need to change it in two places. Oh, Your Honor, that's the,
The plea form says guilty and the
This
actual
was-
form
this
says
was
no
Joe Bear's
contest.
paperwork, Your Honor.
Oh, let me see.
Uh,
Got the wrong one.
So
Oh.
I already erased that, so we'll need to get her to
Okay,
reinitial that when everything's up.
okay. Let me do this here. Okay, Chisholm. Okay, it is not, okay. Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Now, he got two, one of them was, let me erase that one that he had. I guess he tried to, it was Class B was checked and the Class B misdemeanor, and I think they must have tried to erase it. Okay, now, Mr. Chisholm, I also have before me a document. Now, let me do this now, Mr. Chisholm, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Now, I also have before me a document that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials, two sets of initials. The first set of initials is on a line that's checked, the contingent, which means no contest, and it's below a paragraph that is titled waiver. Are these your initials?
Yes, sir.
The second set of initials is below a paragraph that's titled Discovery Admonishment, and it's next to a statement that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty and no contest. You place your initials on this document.
Yes, sir.
On page 3 of the same document, there's a signature above the line. It's titled Defendant, is this your signature?
Yes, sir.
On the next document, it's titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials that, well, at the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have now, Mr. Chisholm, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Chisholm, are you a citizen of the United States?
Yes, sir.
Stay up for stage one.
Now, Mr. Chisholm, the state is offering State's Exhibit number 1 to be used as evidence. State's Exhibit number 1 is the first document that I showed you on the tablet. Same document that have your initials in these two locations and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection, states exhibit number 1 will be admitted. Mr. Chisholm, is there any evidence that you are currently mentally incompetent to stand trial? Send Chisholm's case back to me. Okay, Mr. Chisholm, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
For defendant's plea of no contest, the state has offered 90 days probated over 1 year with a $500 fine, 40 hours community service, and DWI standard conditions of probation.
What is this court cost?
I'll just send this one. Now, look at that one. I'll just pass it to you.
Okay, Mr. Chisholm, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll be required to pay a DWI conviction fine of $100. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and a reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $173 a month. Will you be able to pay the $173 each month?
Yes, sir.
You'll also be required to perform 40 hours of community service, attend and complete a DWI education class, have an alcohol assessment, adhere to the other standard terms and conditions of probation. Mr. Chisholm, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Chisholm, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Chisholm, this will conclude your case. Please stand in front of the court coordinator. Follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day. Schubert. Ms. Schubert. Now, Ms. Juba, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Now, Ms. Juba, you may put your hand out. Now, Ms. Juba, before we get started, you have a right to have a record made of this case, which means you have a right to have a court reporter to type down everything that's being said, or you have a right to waive your record. Do you waive your record or do you want a record?
I'll wait.
Okay, waive it. Okay, and who else we have after?
Joseph Williams, Your Honor.
Yeah, that one on 72.
Okay, that's Mr. Williams. Do you want a record or do you waive it? Wait, okay, so that's that'll be it, so we don't need, okay. You can go, thanks a lot. Okay, now, Miss Juber. Did I swear you in?
Yes, sir.
Okay, sure. That's right, we ain't got started before. Miss Juber. I have before me a document, two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on this document?
Yes.
Now, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge? Okay. Miss Jubert, the first case, let's see. 10. Okay, Ms. Jubert, your first case is cause number 24 CCCR 1810. And in this case, I have a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, how you pronounce your first name?
Antalia.
Antalia? Okay, you, Antalia Juba, on or about June 23rd of 2023, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of resisting transportation. Ms. Juba, do you understand what you've been charged with?
Mhm.
And to this charge, how do you plead guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Because I'm guilty.
Okay, now, Ms. Judy, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, there are two sets of initials. First set of initials is below a paragraph that's titled Waiver, and it's on a line next to a box that's checked guilty. Did you place your initials in this document? The second set of initials is below a paragraph that is titled Discovery Admonishment, and it is on a line next to a statement that reads as follows: I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter or plead guilty or no contest. You place your initials on this document as well. On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Sir.
Now, Ms. Juba, before you sign and initial these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Juba, are you a citizen of the United States?
Yes, sir.
State.
Stay up for 6-1.
Now, the state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is this first document that I showed you on the tablet.
Mhm.
Same document that have your initials in these two locations on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection. State's Exhibit number 1 will be admitted. Ms. Juba, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Ms. Juba, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is to, 180 days prorated over 1 year. Your Honor, is this the resisting of the DWI?
This the resisting.
Okay. On that case, the fine is waived, 60 hours community service. And, that is to run concurrent with cause number 24 CCCR 2509 and states dismissing 24 CCCR 2510.
And dismissing. And in this case, what's the court cost? That's the 277. Now is, let's see. Okay. Okay, now, Ms. Jubert, the state is offering that you serve 180 days in Jefferson County Jail. You will not have to serve any time in Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you will not be required to pay a fine. You will be required to pay court costs of $277. You'll also be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments in this case is $108 a month. Will you be able to pay the $108 a month?
Yes, sir.
Now, I know you have another case. Is you getting probation in that other case too?
That's correct.
Okay, so what's gonna happen? If you get probation in that other case, you will only have to pay probation fee and a year analysis fee in one case, not in two cases.
Okay.
Okay,
Yes, sir.
so, let me do this. So there's a possibility. Let me see, 2 seconds. So there's a possibility that you only be paying $27 a month on this case, okay? Because I'm thinking this is the one you probably had a probation fee in the other case and not in this case. So if they do that, you'll only be paying $27 a month instead of $108 a month.
Okay, yes,
You'll
sir.
be able to pay that?
Yes, sir.
Okay. Now, this case, you'll also be required to perform 60 hours of community service. This case will run concurrent with cause number 24 CCCR 2509, and the state will dismiss cause number 24 CCCR 1810. Do you understand that?
Yes, sir.
Now, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Ms. Jubert, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Jubert, we will move on to your next case. Your next case is cause number 24 CCCR 2509. And in that case, I have before me information. And in this information, Ms. Jubert, it alleges that you, Atalia and Talia L. Jubert, on or about November 18th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Ms. Jubert, do you understand what you have been charged with?
Yes, sir.
And to discharge, Ms. Jubert, how do you plead? Guilty, not guilty, no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty?
Yes.
Ms. Jubert, I also have before me a document that is titled misdemeanor plea admonishment. You recognize this document?
Yes.
On page 2 of this same document, there's a set of initials. Oh, okay, she was supposed to put her initial.
Oh,
That's the one
well,
that was
the one we
erased.
gotta erase.
Yeah. Accidentally erased your initials on that one. You have to,
Read the initial on that one. Sorry about that. Thank you.
okay. Now, Ms. Jubert, I have before me a document that's titled, well, on page 2 of the same document, misdemeanor plea admonishment, there's 2 sets of initials. First set is on the line that is titled guilty. Did you place your initials here? Second line is below a paragraph that is titled discovery admonishment, and it's on a line next to a statement that reads, I do not request discovery of the evidence. In this case, I waive my right to request discovery in this case and I choose to enter a plea of guilty or no contest. Did you place your initials on this document? On page 3 of the same document, there's a signature on the line that's titled defendant, is this your signature?
Yes.
On the next document that's titled trial court certification, the defendant's right of appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of these documents, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Second box that's checked states that you're waiving your right to an appeal. Do you understand that?
Yes, sir.
Now, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Jubert, I read your answers. And state.
Sanford states one.
The state is offering state's exhibit number 1 in this case. State's exhibit number 1 is the first document that I showed you. That's the document that have the 2 initials, second page, and your signature on the first page. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objection, state's exhibit number 1 will be admitted. And the court is going to accept Ms. Jubert's plea of guilty. The court will find that she is mentally competent to stand trial. Court will also find that her plea and waivers were freely and voluntarily given. And the court will also find that there is sufficient evidence to find her guilty beyond a reasonable doubt. State, do we have a plea bargain in this case?
We do, Your Honor.
And what is the plea bargain agreement?
The agreement in this case is to 180 days probated over 1 year with a $500 fine, 60 hours community service, the installation and maintaining of an interlock device, and DWI standard conditions of probation. This case is run concurrent with 24 CCCR 1810, and the state dismissal on 24 CCCR 2510.
377 is a good cause. Okay. Okay, now, Ms. Jubert, the state is offering that you serve 180 days in Jefferson County Jail. You will not have to serve any time in Jefferson County Jail. You'll be placed on probation for 1 year. During the 1-year probationary period, you'll be required to pay a fine of $500 plus court costs of $377. You'll be required to pay a DWI conviction fee of $100. You'll also be required to pay a probation fee of $60 a month, your analysis fee of $15 a month and reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay in this case is $172 a month. Will you be able to pay the $172 a month?
Yes, sir.
Okay, you'll also be required to perform 60 hours of community service, install the interlock in any vehicle that you own or operate, attend and complete a DWI education class, have an alcohol assessment. You also be required to pay Jefferson County DWI initial evaluation fee of $125 on the day of completion for the evaluation you needed. You'll be required to pay an additional $50. Now you'll also be required to adhere to the other standard terms and conditions of this probation. This case will run concurrent with cause number 24 CCCR 2510, and the state will be dismissing cause number 24 CCCR 1810. Ms. Juba, do you understand the state's offer?
Sir.
I think that the state's offer in your case is fair and just,
Yes, sir.
and do you accept the state's offer?
Yes, sir.
Ms. Juba, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Juba, this will conclude your case, your cases. Please stand in front of the court coordinator and follow the directions of the bailiff. Once you follow the directions of the bailiff, you'll be free to go. You will also get a copy of the dismissal as well before you leave. Wait, let's see. Was that Joseph Williams? Mr. Williams, you can please raise your right hand. Mr. Williams, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Okay, you may put your hand down. Now, Mr. Williams, I have before me two documents. The first document is titled Judge's Explanation of Defendants, Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line as titled defendant? And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Enter Guilty Plea Proceeding to Trial. You recognize this document? And is this your signature on the line as titled defendant? Now, Mr. Williams, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Williams, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Williams, it alleges that you, Joseph Maxwell Williams, on or about June 25th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of failed to identify giving false or fictitious information. Mr. Williams, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest.
Yes.
Now, you pleading guilty freely and voluntarily?
Really?
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Williams, I also have before me a document on my computer that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. Did you place your initials, the first set of initials on a line next to boxes checked guilty?
Yes, sir.
And the second set of initials is below a paragraph that is titled Discovery Admonishment. And it is next to a statement that reads, I do not request discovery of an evidence. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that's titled defendant. Is that your signature? Now, on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that statement? Now, Mr. Williams, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Williams, are you a citizen of the United States?
Yeah, for states one.
Mr. Williams, the state is offering state's exhibit number 1 to be used as evidence in your case. State's exhibit number 1 is the first document that I showed you on this tablet. This is the same document that had your initials in these two locations and your signature on page 3. Is it all right for the state to use this document as evidence in your case? Mr. Williams, is there any evidence that you are currently mentally incompetent to stand trial? Okay. Now, Mr. Williams, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The agreement in this case is to 6 months deferred probation with a $200 fine and 24 hours community service.
Okay, what is this court cost? Okay, Mr. Williams, the state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you'll be required to pay a fine of $200 plus court costs of $277. You'll be required to pay a probation fee, $60 a month, your analysis fee of $15 a month, a reimbursement fee of $15. Your total monthly installments will be $188 a month. Will you be able to pay the $188 each month?
Yes, sir.
You'll also be required to perform 24 hours of community service and adhere to the other standard terms and conditions of probation. Mr. Williams, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Mr. Williams, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Williams, if you successfully complete this probationary period, this case will be dismissed. It will not result in conviction and record, and you may qualify for non-disclosure. You can talk to the attorney about the non-disclosure. Please stand in front of the court coordinator, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go, and you have a blessed day. Oh. Oh. I need the gentleman that came up earlier. I just sent him what's his name? Right here, sitting in front of you. It's Mercantile.
Yes, sir.
Okay, now you've already been arraigned, and so but you're gonna have to come to court and sign the paperwork.
Yes, sir.
Okay, so we're gonna set it. We're gonna give you a court date, and you need to be in court on person on that date.
Okay.
Okay, December 17th.
Yes.
Okay, this case will be reset to December 17th of 2024 for announcement, and at that time, you're gonna sign your paperwork. You're free to go, and you have a blessed day. Stay in contact with your bondsman in this
Yes,
case.
sir.
All right, you have a blessed day.
You too.
Thank you.
Well.